Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. Well, it gives me great pleasure to introduce our distinguished speaker for today's session. She's a renowned lawyer, a highly respected solicitor, someone who boasts of a brilliant academic record. Our guest speaker for today is Miss Parinaz Madan. Parinaz graduated as a lawyer from Government Law College, Mumbai in 2011 and was designated as a solicitor in 2014 after passing the highly competitive solicitor's examination conducted by the Bombay Incorporated Law Society. She has, among other academic awards, been the recipient of the Outstanding Pupil Trophy for her performance at the Maharashtra State Board SSC examinations. She also has a string of professional certifications to her credit, including a Certificate of Excellence from Rainmaker for scoring the highest percentage in an advanced contract drafting course. She started her career working in the corporate law team of Crawford Bailey and Company, a leading Mumbai-based law firm. Thereafter, she was an independent legal advisor to the Mahindra Group, where she worked on a host of corporate and commercial law matters, such as drafting business policies, contracts, and legal opinions. She was also a core team member for several mergers and acquisitions of the Mahindra Group. Subsequently, she accepted a consultancy opportunity at L'Oreal India Private Limited, where her work involved drafting high stake celebrity influencer and collaboration agreements, advising the company on various advertising and commercial laws, and drafting critical policies for the company. Upon completing her assignment with L'Oreal last year, she was appointed as a principal associate at Anoma Legal, a multi specialty Indian law firm, a position that she continues to hold currently. In addition to general commercial advisory work, she is actively involved in the firm's research and pro bono initiatives. As a member of I Pro Bono since 2016, she has counseled various NGOs on a host of education, child rights, and medical laws in India. In particular, she has drafted child protection policies for various organizations and recommended best practices for dealing with their child abuse cases. In 2020, she wrote one of the first definitive legal research papers on drafting effective child protection policies for civil society organizations in India and was consulted by representatives from UNICEF and Enfold India for her views on the draft of a state level child protection policy. Apart from child rights, she's also written articles on various themes such as disability rights and feminism. Her articles have featured in BBC News, Business Standard, and India Development Review, among other publications. Now, the topic under discussion today is adding legal value to company policies. This is a first of its kind presentation on our channel, and to the best of my knowledge, on any other legal forum in India. Given her considerable experience in advising various organizations on their policies, she's uniquely positioned to give us some interesting perspectives on this crucial topic. Thank you, ma'am, for taking out time for readily saying yes for doing a session. Anything that you wish to say before you
Yes.
proceed with
So
the
thank you, Jay, first of all, for your very kind introduction and importantly for spearheading this very, very valuable initiative for lawyers and law students alike. And to my mind, your channel has been instrumental in imparting insightful and importantly, actionable advice to legions of professionals in the legal field. Now, I hope to contribute in a very small way towards this enormous body of knowledge existing on your channel. As you've mentioned, my topic for today is adding legal value to company policies. And while I have used the word company in the presentation's title, the general principles of policy drafting discussed today could be applied equally to organizations of all forms and stripes, including NGOs, with some modifications, of course. In a sense, I intend to provide some insights into my personal experience of helping organizations draft and review policies. Now, that begs the question of why should we as lawyers even care about company policies? Is that really our domain? Now, as you know, policy drafting and reviewing was considered to be, traditionally speaking, the area of expertise of the human resources department of an organization. But in my experience over the years, lawyers have been brought on board to draft or opine on such policies increasingly. And as is evident, one of the chief reasons for this is to protect the business from legal and reputational risks, because a policy becomes a gateway of sorts to communicating an organization's work culture, strategies, and importantly, legal compliances to the outside world. Very recently, policy disclosure requirements for businesses have also been stepped up under the new ESG regime, which stands for Environmental, Social, and Governance. And I will discuss this in more detail in the upcoming slides. But when a brief of policy drafting or reviewing comes to us for the first time as lawyers, we are frankly quite dumbfounded because our legal training does not necessarily equip us for the task. While you will find an abundance of books on contract drafting, very limited legal resources are available for policy drafting and reviewing. So you essentially have to learn this skill on the job. I'm going to give, I'm going to attempt, I would say, to give you a primer of sorts on what I have learned over the years in this domain. And while I'm still a student in this domain, I would like to give you some benefit of my learnings. This obviously is not intended by any stretch of imagination to be an exhaustive or definitive guide on the subject. Now, given the mammoth scale of the topic before us, I have chosen to divide this presentation into the following sections. So firstly, we examine what are policies and why are they crucial. Secondly, we undertake an assessment of policies in the Indian context. Thirdly, what are the broad categories of policies that you as a lawyer can expect to encounter? Fourthly, what is the kind of legwork that is vital before drafting a policy? Crucially, the next two slides here will elaborate on the structure and content of policies, followed by a few tips and tricks that will help you navigate the policy maze. Thereafter, we delve into some policies that have made headlines recently for a multitude of reasons. Finally, we will conclude with some pointers for effective implementation of policies. So let's dive right in and begin our mountain hike. Okay. So first of all, what are policies? What pops up in your mind immediately when you hear of this word? A set of rules, a guide to decision making, perhaps? As you can see in this slide, the Cambridge Dictionary defines the term as a set of ideas or a plan of what to do in particular situations that has been agreed to officially by a group of people, a business organization, a government, or a political party. So simple enough, policies are a set of ideas or an action plan that bear some sort of official stamp of approval. Now, for the purpose of our presentation, we are obviously examining only business-related policies, government or public policies which affect the public at large, while an extremely fascinating topic are not on the agenda for this particular presentation. So in that vein, whenever I use the word policy in this presentation, it obviously refers to business or company policy and not public policy. Another definition to consider is one by management author Stephen Page, who defines policy as a predetermined course of action established as a guide towards accepted business strategies and objectives. So while policy is synonymous with a plan, idea, course of action, etc., a procedure, as you'll see in the next definition, is a method or means by which a policy can be accomplished or attained, essentially the how-to, okay? Some organizations like to keep policies and procedures separate, while others may choose to combine them in one document, and either approach is fine. You will also hear all kinds of terms and interesting coinage like protocols, SOPs, standards, guidelines, etc., floating around in a corporate setup, and different companies will attribute different kinds of meanings to them. But as a rule of thumb, think of policies as chief or principal binding documents and the other documents as supportive ones which elaborate on the policies. So it helps to visualize a policy as your protagonist or chief actor in a movie and the procedures, guidelines, etc. as the supporting cast. Okay, now we move on to the importance of policies in an organization. So whenever you, as a legal advisor to a company, get pushback for suggesting a robust written policy to the company's management, you can keep these points in your arsenal. I think a lot of the points mentioned on this slide become quite apparent and obvious to us upon a bare reading of the very definition of policies. So let me illustrate by way of some examples. Assume that a woman, as depicted in this picture on the slide, wants to join a company. The posh policy of the company which, as most of you may know, deals with protecting women from sexual harassment at the workplace, will set out the objective of the organization of providing a safe working environment to women. Then certain expected forms of behavior, for example, that employees should report sexual harassment to the authority designated under the policy, and certain prescribed forms of behavior, for instance, that employees should refrain from various forms of unwelcome acts, will also be laid down in the policy. Hence, as mentioned in the first point on this slide, policies set the goals of the organization and clarify expectations. Now, the POSH policy will also have a committee to monitor its compliance. And in India, that's typically called the Internal Complaints Committee. And in doing so, it will chalk out the roles and responsibilities of the employees who form part of the committee. For instance, the designated committee members have to maintain strict confidentiality of the complaint. So as set out in the second bullet point here, policies clarify roles and responsibilities of employees. By laying down such roles and responsibilities, consistency in decision-making is fostered and capricious actions on the part of the organization are mitigated, because now the organization actually has a rule book of sorts to deal with sexual harassment complaints. This explains the third bullet point that I have captured here, which is that policies ensure consistency in decision-making and actions and prevent arbitrariness. Now, say if the female employee is planning on having a child in the next few years, she can rest assured by reading the leave policy of the company that it will give her the requisite amount of leave, which, as you know, is 6 months mandated by the law under the Maternity Benefit Act 1961. Some companies may choose to go above and beyond this mandatory period and offer, say, 9 months of leave or allow an extended work from home period. Clearly, all this will go a long way in boosting her satisfaction as an employee and also enhance the preparedness of the company in dealing with such situations in the future. This covers the fourth and fifth points on the slide, which are well thought out policies, enhance preparedness for future events, and boost employee satisfaction. Interestingly, in my experience, some companies have also started offering pet leaves, which accommodate adoption, sickness, or death of pets for their employees who are pet parents, although not legally mandated to. Needless to say, when such policies make headlines in newspapers or travel far and wide, simply by word of mouth, they bump up the company's reputation and become magnets for attracting good talent. Thus, as exhibited in the sixth and seventh points on this slide, policies communicate corporate culture to new employees and bolster the organization's reputation. In fact, in my experience, a lot of companies, particularly multinationals, spend a sizable portion of their time and resources on just training new recruits on company policies. And last but not the least, and this is most interesting for us as lawyers, policies aid in ensuring compliance with the laws. For example, the POSH Act and the Maternity Benefit Act, which we just discussed. And what it does is it mitigates both legal and reputational risks for the organization, right? We will elaborate on these aspects in the forthcoming slides. Okay, now that we have a fair understanding of the general significance of policies, let's turn our attention to their relevance in the Indian context. Now, if you were to ask general counsels of listed companies today, what has been one of the most compelling factors in recent times that has nudged them into revisiting their company policies, they will most likely mention the BRSR framework. This is an acronym for the Business Responsibility and Sustainability Reporting Framework, a bit of a tongue twister, I must admit, but this framework has revolutionized the disclosure landscape for the top 1,000 listed entities in India. Effective from the financial year 2022-23, such entities must report their performance on key environmental, social, and governance aspects and demonstrate their commitment to responsible business practices in their annual report. Now, one of the ways of demonstrating that commitment is to prepare policies based on the principles and core elements of BRSR. Now, to give you an example, policies ranging from anti-corruption to sustainable sourcing are required to be kept in place under this framework. It is worth mentioning here that BRSR is an extremely dynamic concept, and while very well intentioned, has given many a general counsel sleepless nights. In recent times, BRSR core, and you can read up further about it, which among other things requires certain listed companies to make disclosures about their value chain partners, has further enlarged the disclosure obligations of such companies. Now, moving on to the second point. typically, if an Indian company is a subsidiary of a global corporate, the global corporate may want to hand down some policies to the Indian company for adoption. Needless to say, when this is done, you as a legal advisor will have to vet the policy through the prism of Indian laws and not international laws. And thirdly, a lot of times you will be approached right at the 11th hour by an organization for a policy drafting exercise because a collaboration or a transaction or a funding won't go through or will come to a complete standstill unless the organization has certain policies in place. We have seen such conditions being typically imposed by international lenders, funders, or collaborators. Okay. Now, very broadly speaking, and I mean at a macro level, what are the categories of policies that you are likely to encounter as a lawyer? So you can see the distinction on the slide. Firstly, you have mandatory policies, which are required to be prepared by the current laws in force. And secondly, discretionary policies, which are not mandated by our laws, but are drafted at the discretion of the company. So we have already discussed one example of a mandatory policy, POSH policy, that is, in the preceding parts of my presentation. Now, I think a lot of you may know that all organizations having 10 or more employees are required to formulate a policy against sexual harassment of women at the workplace under the POSH Act 2013. Now, while this is a much publicized and well-known legal requirement, not many organizations are actually aware that they all have to frame and publish an equal opportunity policy under the Rights of Persons with Disabilities Act 2016, irrespective of how many employees they have. Okay. Now, what is this equal opportunity policy? An equal opportunity policy typically outlines an organization's commitment to non-discrimination of employees on the grounds of disability and lays down the facilities and amenities that the organization will provide towards that end. I also want to briefly touch upon the fact that listed companies are subject to a much, much higher degree of scrutiny than their non-listed counterparts and consequently have to draft a number of additional policies such as insider trading policy, whistleblowing policies, etc. Now, this list that you see on the slide, beware, represents only a smattering of mandatory policies for companies in India. In order to assess all the policies that an organization is required to draft under the applicable laws, it is crucial to understand its nature of work, legal structure, governing authorities, number of employees, and location, among several other factors. But these are the key ones. Also, it's worth noting here that a failure to draft certain mandatory policies could lead to a whole gamut of consequences, ranging from fines to cancellation of businesses also, business licenses in some cases. Moving on to the second category of policies, now the discretionary ones. These are not compulsory under our laws, but an organization's management may choose to adopt them for a whole range of reasons. Now, to give you some examples, a company with multiple subsidiaries, may adopt a trademark policy to ensure the effective use and preservation of its trademarks by such subsidiaries. Or a company may draft a domestic violence policy in order to assist female employees who are victims of such violence by providing them counseling, leaves, etc., even though it's not compulsory to formulate such a policy in India as of today. Likewise, in order to ensure efficient creation, storage, and execution of contracts by various departments of a company, a contract policy may be formulated. Okay. Now, when an assignment of policy drafting or reviewing comes your way as a lawyer, how should you approach it? There is no one right or wrong way to do it, but this is my preferred way. First of all, get a crystal clear brief from the management of the organization that has approached you. And in that vein, ask questions such as what prompted the idea of executing the policy? Was it in anticipation of a new law or government policy or a prerequisite for a collaboration? Next, delve into the current organizational practices and procedures governing the subject matter of the policy with a magnifying glass. Because if there is a policy in place already on the subject matter, you need to analyze and figure out where its shortcomings lie. After all, the new policy that you are tasked with has to address these gaps. Then inquire about who will be the key stakeholders involved in the implementation of the policy. So if it's a mobile phone usage policy, are senior members from the IT team going to be the policy's key executors? Try to strike up a conversation with such stakeholders because it is best to get all your information about the intention of the policy and potential implementation hurdles, if any, straight from the horse's mouth. And now, the two most crucial points which I cannot emphasize enough on. Firstly, read up all you possibly can about the relevant laws governing the subject matter of the policy. Sometimes the challenge is that it may not be patently obvious what laws would directly apply to a policy at hand. So you will have to give it careful and considered thought. For example, if you've been asked to prepare a policy on how a government should respond in case of government investigation, how a company should respond, in case of government investigations, you will have to undertake a thorough assessment of all the relevant criminal laws in addition to any corporate laws that might apply to the policy. Personally, I also like to keep a separate document detailing all my background research handy and to insert the relevant portions of my research as track mode comments in the policy draft. So for instance, if my policy reads as the employees must do XYZ, I tend to add a track comment against that statement with my research stating that XYZ is mandated under such and such law. Now, why do that? By providing legal justifications in writing for every important statement that you're making in the policy, you tend to save on time because this obviates the need of providing verbal accounts to various stakeholders involved in the policy's review. And sometimes there can be many, many stakeholders. The policy draft will speak for itself, and this approach will go a long way in evolving quick consensus. And obviously, once consensus has been obtained, you can keep one draft with the track notes for your future reference and delete the track notes in the final copy of the policy document. Now, last but not the least, read up as many newspaper articles and templates as possible from credible sources over the internet. And I reiterate, credible sources. Articles will give you a well-rounded perspective on the successes and failures of companies who have been there and done that. And high-quality templates could serve as a good starting point for building your own policy draft. Okay. This is a long one, and we need to take a deep breath before this. Armed with all this preparatory work, you can now commence the actual policy drafting exercise. So let's consider the anatomy of a policy. That is, what should its structure look like? Now, once again, there is no one right or wrong way to structure a policy, but personally, I like to keep the list displayed on the slide handy whenever I'm drafting a policy to ensure that I have not omitted any crucial points. You may visualize these points as building blocks. Firstly, and most obviously, you need a title for your policy. For instance, a mobile phone usage policy. Okay, the title should be crisp, but should convey the subject matter of the policy clearly. Next, you should mention the authority within the organization who is issuing this policy and who will take charge of it, who will take ownership of it. For instance, President HR or President IT. Okay, just to give you some examples. Then we write out a series of dates, the date from which the policy will be implemented, which is the effective date, the date when the policy will be released, which is the release date, and which, by the way, can be the same as or different from the effective date. If there was a previous version of the policy in place, the date when the policy was last reviewed, and the next review date, which could typically be a year or a few years down from the policy release date. So why have all these dates? By having all these dates in place, you are essentially charting the chronological sequence of the policy and ensuring that the employees are aware of the dates from which the implementation and review related obligations start kicking in. The next point that you see on the slide is version and version history. Now, this applies only if your present policy is an iteration of a previous policy, in which case you write the current version number, say version number 3, and provide a small brief snapshot of version 1 and 2, which is the version history. Okay, now let's target the more pivotal parts of the policy. The scope, which sets out the applicability of the policy, is extremely important to signify who the intended audience of the policy will be. Does this policy apply uniformly to all the employees, or is it intended only for a specific division of the company? Does it apply only to the employees or also to the company's consultants? Equally important is the next point, objective of the policy, which should spell out the aims and objectives that the policy seeks to achieve. By way of an illustration, if it's a mobile phone policy, the objectives could be, and I'll just read out, establishing rules for the use of mobiles by the company's employees and clarifying acceptable and prohibited forms of usage. Okay, just to give you an instance. Now, closely tied in with objectives is a policy statement, which essentially demonstrates the company's strategy and commitment to put the policy objectives into action. For example, again, going back to our mobile phone usage policy, a policy statement in such a policy could be along the lines of, while the company acknowledges the necessity of mobile phone usage for effective communication, reckless use of phones could pose a serious risk to its data, reputation, and security. Hence, the company is committed to put into force certain measures to prevent risks while also balancing the rights of privacy and expression of its employees. Then comes the definitions part, which should only be added if merited, and just, as you would in a contract, to throw light on important and repeated terms in a policy. Then comes a part on obligations, and this is critical. Here you will sketch out the general obligations of the employees. For example, the employees must comply with the company's IT security system while using their mobile phones and must not download software on their mobiles that's, say, expressly forbidden by the company's IT department. Then you detail the specific roles and responsibilities of the concerned individuals who will be responsible for ensuring the implementation of the policy. For example, the vice president of the IT department in this case will be responsible for implementing the policy, and towards this end, he will have XYZ responsibilities, whatever the company deems fit. Now, in certain cases, you may also require to have a full-fledged reporting and grievance redressal mechanism. For instance, I had spoken briefly in one of the previous slides about the Internal Complaints Committee under the POSH Act, which is tasked with the time-bound settling of sexual harassment complaints. In certain policies, like leave policies, you may have an approval mechanism, okay, where an employee would simply need to seek the written approval of his manager for taking, for example, casual leave. Now, a very significant heading under this slide is that of consequences of non-observance or breach of the policy. This is the section which essentially adds teeth to the policy. Depending on the seriousness and context of the policy, such consequences could range from receiving a reprimand and undergoing counseling sessions to more serious disciplinary action like dismissal, suspension, or even removal of the offending employee. Okay. Now, the last few headings may seem to be supplementary in nature, but are actually quite important. Having a provision for contact person allows the reader of the policy to know who to approach if he or she has any questions, concerns, or complaints regarding the policy. It is wise to provide a functional email ID, of course, for this purpose. Then a provision for revisions allows the company to reserve the right to amend the policy at any time as it deems necessary. And finally, with a related documents provision in place, the company can make a list of all the policies which must be read in conjunction with the present policy so as to provide a holistic view to the reader. So if we had to go back to our previous example of a mobile phone policy, related policies which supplemented typically would be the company's social media policy or IT security policy, etc. And last but not the least, make sure that the signature and date of signature of the issuing authority is present at the end of the policy. Now, having discussed all this, it is pertinent to point out here that some organizations have a house style for what their policy should look like, or may ask you as a lawyer to create a style for them. Moreover, some of these points on the slide may not apply to certain policies, and some policies may require additional headings. For example, a lot of you have heard of privacy policy that you see on a company's website. That's a whole different beast altogether and will merit a different kind of format. So I would highly recommend that you treat this slide only as a rough guide of sorts. Okay. Okay. Now that we have discussed what a policy framework should roughly look like, let's examine some tips and tricks for the content of the policy. Once you have a rough draft in place, ensure that you review your own draft first using these points on the slide before submitting the draft to a larger audience. So firstly, as you would in most forms of writing, keep things simple, brief, and clear. Brevity in particular is not typically considered to be our strong suit as lawyers. And we often hear the common refrain of how much lawyers like to complicate and lengthen documents out. But do try to be as concise as possible, especially in the light of ever-dwindling attention spans that we have to face. There are three ways that come to my mind for keeping policies concise. And trust me, it's a challenge when you actually get down to doing it. So there are three ways that I personally employ. The first way to do this is to cut out all the unnecessary aspirational details from the policy. For example, you will observe that a policy may contain a lot of statements underlying the general philosophy of the company, which may not be relevant to that particular policy. Cut them out. For example, the POSH policy is not the right place to reiterate the company's general commitment to carbon neutrality. But you will find these, kind of statements in the policy and realize, oh my God, this has become really, really bulky. Then the second way, another way that's commonly employed by organizations to keep their policies trim is to keep the procedures in a separate document from the policy document. That way, most employees will know the bare minimum that they need to about the policy without being bothered about the detailed procedural steps involved in attaining the objectives of the policy. Those employees who bear responsibilities under the policy, say if they are members of a grievance committee, can always consult the procedures document to better understand the procedural aspects which are applicable to them. And then another method, and again, an obvious point to keep your policy short is to not restate the law in the policy. As I had mentioned earlier, you can make track notes of the applicable laws in your policy while circulating the draft for consensus among the organization stakeholders. But really, there is no need to clutter the main body of the policy document with legal sections and provisions. Just like, we would not write in the consideration clause of a contract that X agreeing to pay Y 1 lakh rupees is lawful consideration under Section 23 of the Indian Contract Act, right? You would not do that. However, if you really, really want to draw attention to a critical legal provision in your policy, you could write out a line or two under a please note heading, but truly and honestly don't do that unless it's absolutely essential. Now that ties in with my second point on this slide, avoid unnecessary jargon. Words like prima facie, meaning on first impression, may be well understood in the legal fraternity, but may leave most other readers absolutely perplexed. So please avoid using such terms in your policy. Then thirdly, ensure consistency in terms and language. We tend to get a little lax about this in policies, but we should give defined terms as much importance here as we would in our routine contracts and ensure that they are used consistently throughout the policy. Otherwise, your policy will be in a state of complete disarray and the reader will end up getting puzzled. Fourthly, use language of discretion and compulsion wisely. So it's preferable to use must for mandatory obligations and may for recommendations. Fifthly, stop copy-pasting precedents blindly. Slavish adherence to any precedent, whether international or Indian, can be highly, highly problematic because a policy has to be tailor-made to suit the peculiar nature, function, and location of each organization. Now, to give you an example, okay, if you were to pick up an international precedent on a contract maintenance and execution policy, say from the US, it is not going to provide for the payment of stamp duty charges on commercial contracts as required in India, because international laws vary widely on the subject of stamp duty. Now we come to the heart of the matter by way of the sixth point, which is please do not fall afoul of the law. See, it sounds like quite a truism and may seem clearly obvious, but it is an important consideration to keep in mind nevertheless. Consider what the law mandates to be the bare minimum and ensure that your policy is at the very least compliant with it. For example, a company's maternity policy is free to offer 9 months of maternity leave to its employees, which is beyond the 6 months prescribed by the law. But under no circumstances should it be limited to 5 months, right? Also, given the enormous amount of time it takes to achieve consensus from various stakeholders at a company for operationalizing a policy, it is extremely crucial for us as lawyers to check whether the policy is updated with the current laws in force as on the release date of the policy. Now, last but not the least, ensure that you adopt as respectful a tone as is possible and avoid tone-deaf language in your policy. So obviously, don't adopt a bullying or hectoring tone in your policy because no adult will appreciate that in person or on paper. To my mind, it is also extremely crucial that beyond satisfying the basic legal requirements, a policy stays morally and ethically sound. And yes, you may say morals and ethics are very subjective words, but I like to adopt the front page test that is very commonly used among compliance and ethics professionals. So what is this test? In a sense, if you are considering a course of action, but are not sure about whether it is ethical or not, you should take a step back and ask yourself, would I be comfortable if this course of action was reported on the front page of a newspaper and read by my family, friends, and acquaintances? If the answers are hard no, then don't do it. I would suggest that whenever you're posed with such policy related dilemmas, adopt this front page test. Would I be okay if the policy provision that I have drafted or that my client has proposed appears on a newspaper's front page or goes viral on social media? Now, speaking of the front page test, I think it is an important, an opportune time to proceed to our next slide. Okay. Now, let's take a quick look at some companies whose policies have made headlines in recent times. Now, as all of you know, Google is consistently ranked as one of the best companies in the world to work for. And one of the primary reasons for this is its employee friendly policies. So you can see on the first part of this slide that Google's move to increase its employee vacation days for caring for newborns and seriously ill relatives just 2 years ago earned plaudits and appreciation, not just from its employees, but also from the media. Now, let's juxtapose this with the next headline here from some months ago, where Google's strict work from home policy earned criticism from several quarters for being tone deaf and intrusive. To quote the Mint article here, being treated like school children, Google employees on stricter work from home policy. Google's decision to include badge checking and attendance and performance review has left employees disappointed and frustrated. Now, I have merely used Google as an example here because it is a huge corporation whose policies have made headlines with increasing frequency over the years, but a number of other tech giants have also been critiqued for similar reasons. Closer home, in India, you can see that Swiggy's moonlighting policy had attracted a lot of attention 2 years ago. This moonlighting policy essentially allowed Swiggy's workers to take on projects outside of office hours or over the weekends, provided such work did not impact their productivity or conflict with Swiggy's business. A lot of companies have actually taken very strong positions on moonlighting policies, particularly in the tech sector. And as a lawyer, you may be called upon to help companies navigate this very debated and contested subject. Then, as you can see, the other news article, in 2020, Zomato had announced paid period leave for its staff and had received a lot of appreciation for taking on a common workplace taboo. Some organizations are contemplating providing such menstrual leave, even though it's not mandatory to do so under our current laws, and may seek legal counsel on structuring such policies. Now, I have just chosen the companies mentioned in these slides at random, and I have really nothing for or against them, nor do I vouch for these articles representing the current position of these companies. But I do hope that these articles have helped demonstrate the massive impact that policies can have on an organization's image and the role that lawyers can play in bolstering an organization's reputation and also averting a potential reputational crisis. Before we conclude this presentation, I want to briefly touch upon one topic that we as lawyers are not always directly involved in, but are expected to advise management on nevertheless. And that is, sure, we have a glittering brand new policy in place, but how do we go about actually implementing it? So I've jotted down a few tips here in that regard. Firstly, it is crucial to build meaningful consensus before publishing a policy. For example, if you're suddenly jumping from a 5 days a week work from home to 5 days a week work from office policy, it is prudent for management to first gauge the reaction of its employees before taking such a dramatic and drastic step. Secondly, ensure that the policy bears a stamp of approval and exhibits involvement of someone from the top management of the company, for example, the CEO. This helps in setting the tone of seriousness among the employees in an organization about the policy's implementation. Thirdly, adopt a carrot and stick approach. And what does that mean? It fundamentally means that you induce cooperation by offering both rewards and punishments. I think we've talked a fair deal about punishments that can be meted out under a policy by way of disciplinary action. But some organizations also like to reward employees who have been scrupulous in following company policies in both letter and spirit. So, for example, it is common to find teams within companies being rewarded for excellence for reducing their carbon footprints and thereby following and furthering the company's ESG policy. Fourthly, some organizations conduct mock drills to reinforce a company policy and assess how well it is working in practice, just like you would have a fire drill. It is vital for someone from the in-house legal team to be a part of this drill for obvious reasons. Fifthly, it helps to have training sessions and quizzes to keep the policy front and center in the minds of employees. And sixthly, a lot of companies tend to publish policy excerpts on the company stationery or emails or web portals if they have any to enhance visibility of company policies. Some companies also use cartoons, Q&A formats, etc. to increase the reader friendliness of their policies. So, feel free to create your own versions of Peter Rabbit and Paddington Bear to enlighten employees about company policies. And finally, I would like to wrap the session up with some concluding thoughts. Drafting and reviewing policies for a company can be quite an onerous and time-consuming undertaking. Yet, I think it gives us lawyers an opportunity to become mini legislators of sorts by making rules that an organization's employees must abide by. But, over and above this, it also gives us a ringside view of an organization's working and gives us very unique insights into employee behavior. Moreover, work of this nature will continue to be quite a staple in our regiments as organizations are increasingly calling upon lawyers to safeguard them from legal and reputational risks. Unfortunately, a lot of lawyers perceive policy drafting to be a byword for boredom. And yes, it certainly is not as gripping as a nail biting thriller. But I do hope that more lawyers take an active interest in this fascinating domain and leverage their creativity, research, and critical thinking skills to add meaningful value to company policies. With that, I would like to wrap up. Thank you, Jay.
Very well, ma'am. Thank you so much, ma'am, for taking our time for doing this extraordinary session. Not only a very gripping session, but also a very enriching one. And first of its kind, because this topic has never been covered on our channel before. I've been doing sessions, recording sessions for over 2 years now. June 2021 is when I started recording sessions on my channel. But something that really look forward to all the viewers who are watching. Indeed, a very lucrative, interesting field, something that has not been covered on any other platform. So feel free to write to us. Our email is mentioned on the channel in case if you have any queries or questions with respect to the topic that Parinaz discussed in great detail. Feel free to write to her as well if you want to directly. Anything that you wish to say, before we close in, ma'am, and as parting words, as tips to young law students.
Oh well, no, I just want to say, thank you for having me on this forum, and I think the diversity of topics that you have on your channel is,
Yes.
quite amazing. You can look at a number of topics just by, browsing through your channel, and you can get a lot of in-depth and expert analysis, and as I said, actionable advice. So I would highly recommend that young lawyers look at a lot of the episodes on your channel. I think it'll be very useful for them. And thank you again for having me on this session.
It's indeed our pleasure, and I'm so grateful you took out time and you did this outstanding presentation for us. It's goodbye for now. Thank you so much.
Thank you.